I understand that the U.S. attorneys needed to file a formal trademark application in the U.S. However, does that apply to a letter of protest? Did we cover this already? Can a
No,
Canadian entity submit one, or is it necessary for them to hire a U.S. attorney for this?
that's an awesome question.
Okay.
And I know part of the answer. So the first part, U.S. attorneys needed to file a formal trademark application to the USPTO. Yes, but only if you're not a U.S. citizen. So, if you are a Canadian entity, then yes, you'll have to have a U.S.-based attorney file that application for you in the United States. Now, if you have a trademark in Canada, you potentially could take it to the United States with Madrid Protocol, potentially. That would be
Okay.
an option for you. But the letter of protest, do you have to have an attorney do the letter of protest? I don't know. I really don't know. My initial thought is yes. Yes. But I could be wrong about that.
Very good. And that's a U.S. thing, a letter of protest.
Yeah, I imagine that
What is that from
So if you are aware of a third party that has not been examined yet by the USPTO, you can file a letter of protest, basically doing some research for the examining attorney, letting them know that there's these other companies using the similar trademark, or you're using the trademark already. You're basically just giving the examining attorney a little bit more information to help them make the determination that there's a problem with the application.
Got it.
And
Yeah.
you would do that as opposed to, or maybe in conjunction with an opposition at a later date. So if you're trying to avoid the opposition, maybe you consider doing a letter of protest. And if that's not persuasive to the examining attorney, then you can at least file the opposition.